Good morning. What is dying declaration? How dying declaration be attacked by the defense counsel, and how the prosecutor must insist to accept the dying declaration is very vital subject. See, section 32 of the Indian Evidence Act also deals with the dying declaration. It is not that section 32 of the Indian Evidence only meant for dying declaration. It is meant for the witnesses who could not be procured. But so far dying declaration is concerned, at the time of dying declaration, if the victim gives some statement about the cause of death and assailants, that is admissible. See, first of all, dying duty of the doctor. If anything comes out of the victim, it should be recorded. The Mayur Pabhai Shah vs. State of Gujarat, AR 1983 SC 66, at page 66, it says that doctor evidence is also one of the witness, should be treated as like other witnesses. Dying declaration by gesture. Suppose if the victim is not in a position to speak, then if the questions are put to him, if he gives answer by nodding his head, shaking his head, or fingering it, these things may be recorded. But the judgment says that we should record the question first, then the symptoms exhibited by her also should be stated. That is, should be there. That is what they say. That is Rambira Misir versus Emperor AR 1943 Patna. Of course, the dying declaration must be corroborated with other evidence. Not in writing may be proved, that is also a case. Then fit state of minds of the victim who gave dying declaration must be ascertained. So there you have to see the injuries sustained by him, the medicines administered to him for first aid treatment. All this could be taken into consideration to prove that the accused may not be in a better state of mind. Dying declaration is subject to suspicious declaration. But when a doctor says that even before going to coma, he has recorded the dying declaration, that is admissible. That what it says in Suresh versus State of Madhya Pradesh, 1987, 1 crimes 385, Supreme Court judgment. If there are some two different dying declaration, that may be considered on appreciation of evidence. See, the deceased had 15 injuries. Therefore, the court said there is no possibility of giving dying declaration. Then you see gunshot wounds in liver, lungs, pericardium, and even heart, and became unconscious within few minutes. No dying declaration possible. So these things, for to challenge the dying declaration, you should go the accident report as well as post-mortem injury, anti-mortem injuries. Then they say doctor is bound, doctor or police official bound to call the magistrate. But in AMA Rahman State of Gujarat, AR 1970 Supreme Court, the Supreme Court held that there is no time limit to call for the magistrate to record dying declaration. Under the such circumstances, the doctor is entitled to record dying declaration. Doctor, then they say he was disinterested, respectable witness. That's what they say. Then you see a vertebra column injury, spinal column, so many injuries. That itself says that there is no possibility of giving dying declaration. These all are most important. Today, I think that's all. Thank you.